everyone, and thank you so much for hello everyone, and thank you so much for joining. And this is really awesome that we could do something very important show today. And thank you for joining on AFP Live show Gupshup Global Gupshup. And this is your host Anu. I hope you all had a great July 4th weekend and getting ready for all the tax filing, of course. And while everybody is staying safe, please do keep the social distancing followed. So ever since the COVID-19, the pandemic has started, so we all are facing very new challenges and also the many changes that are happening around the world. And also we are also going through such a difficult time every step of the way, everyday life, work, and so on. So as we all aware, that about today's show to talk about that on July 7th, 2020, the ICE, U.S. Immigration and the Customs Enforcement has announced the many changes that occurred. So what we want to do is we want to help out students also, because the SCVP also announced the notifications and modifications in the regulations. And most of the time, the students are the one in a very sticky situation and going through such a hard time making the decisions and where to ask questions, or has many the visa issues and immigration questions that they have absolutely no help. And so today's show is all about that, and we are going to tell you all about it, who is going to help us. And so to help these students and their families, of course, if they're residing in US. And so the very well-known firm here, the law firm, Patel Law Firm, came forward and offered us help to answer all of our questions. And the very well-known attorney, Mr. Chris Prescott, is with us today in the studio, so that he will be answering, of course, virtually, and many questions that are going to be asked by our audience and viewers. So Mr. Chris is very well known in Dallas-Fort Worth area as well as in USA, because he also handles cases throughout the US. And he heads the immigration department and at the Patel Law Firm. He's a fellow immigrant himself, and originally from United Kingdom, and worked as an attorney for leading the insurance litigation firm. And he moved to US 14 years back, and then he switched to immigration attorney, and he specializes in employment-based immigration and represents many corporation clients. And so he, and not just in Dallas, but throughout the nation. So instead of me telling everything, I think I would like to welcome him live and joining us, so that he can tell us more about the specific questions you may have, or let him give more information. So without further ado, so just let's welcome Mr. Chris. Thank you so much for joining. How are you?
Hi Anu, how are you? Good afternoon. I'm well. Thank you for having me on the show today.
Absolutely. It's a pleasure having you. And like I mentioned, this is a very difficult time for every single the citizen, and and students especially. So today's show, that let's focus on something that what we can help all these students. And so give us a little intro about what's going on.
Yeah, so there's been a lot of immigration changes, not only in the last few months, but in the last few years. Obviously, since the Trump administration began, we've seen a lot of different challenges. Particularly for H-1B holders, for students, for and now immigrants as well. We've in the last, I guess, 3 months, we've seen 2 proclamations, one which applies to immigrants, and then one which applies to non-immigrants, which includes, for example, H-1B holders. And then recently, last Monday, we saw a new rule which applies to F1 students. Right. So I think the way we'll do it is we'll talk about the new F1 rule first, and then we'll talk about the 2 proclamations. I think that kind of makes sense.
Sure. So tell us about in detail, the recent announcement which was made and how actually, like you mentioned, that, the F1 and M1 students, so how it is going to be affected.
Sure. So it was last Monday, July 6th, SEVP announced that any student that would be attending a purely online course, sorry, the light's gone off. It's been, oh, there we go. Any student that is attending a purely online course in the fall semester would either be required to leave the US or transfer to another school. Department of State have also said that they won't issue visas to anyone outside of the US that's coming back for the fall semester where the course is purely online. And then the CBP, which is the Customs and Border Protection, have also said that they will deny entry to anyone that is essentially going to be attending an online course. So just to give you a little bit of background to this, so the original regulation as it applies to F and M1 students requires students to have face-to-face instruction. The only exception to that would be students are allowed to have one class per semester online courses.
Right.
Obviously, with everything going on with COVID, in March of this year, Trump declared a national emergency, and the MVP decided to relax those regulations. So in March, they provided an exemption saying that schools would be permitted to offer online instruction. Students could attend online classes and still maintain their F1 status.
Right.
The expectation was that, that would continue through the fall semester. And certainly, schools had been preparing to offer online instruction. Students had been preparing to continue their online studies. And then, of course, last Monday, they make this announcement, which has obviously thrown everything into chaos.
Right. So, and, like a lot of students are also concerned about that one, that, like how to handle this one, because the fall semester is not too far. So, and why do you think the exemption, which was in place for this, spring, summer semesters, is not extended to all the way to fall? I mean, if I'm correct, right? Like it's not extended until. Okay.
Yeah, it's not extended. It was in place for the spring and summer semesters, and it's obviously not being extended into the fall. I mean, this is really a political move by the president to really reopen the economy and put pressure on schools to reopen. A lot of these schools have a significantly high number of international students. Some schools as high as, over 30%. So by saying that they have to offer face-to-face instruction, it's really forcing the schools to either reopen and at least offer some sort of face-to-face instruction, or to, essentially risk losing students. So when we talk about the proclamations, they're more about limiting legal immigration, which this rule potentially has could do the same thing, because obviously if the schools decide not to reopen, a lot of these students are going to have to leave the US, and these are students to OPT, STEM OPT. But I think the real reason is because Trump wants the schools to reopen, and you probably saw there was a tweet last week saying all schools must reopen in the fall. So this is really just a pressure tactic right now. So, I think that's the main reason it's not been extended through the fall.
So I'm also checking, like if anyone has a question that, that probably we might, but going on with that, so let's also talk about, so do you think this new rule, will be, legal, and maybe do you think it can be challenged in a court, maybe, you think?
It can certainly be challenged, and there's already a federal lawsuit that's been filed by Harvard and MIT. So this announcement was made on Monday, and on Wednesday, Harvard and MIT filed a federal lawsuit in the District of Massachusetts. I read this morning that another 60 universities have filed briefs in support of that federal lawsuit. I think it was last Thursday or last Friday, a federal judge basically gave the government the option of agreeing to a brief stay or proceeding to an injunction hearing, and that injunction hearing is now set for Wednesday. So You know, the federal lawsuit alleges a number of things. First of all, that it's a substantive rule that should have gone through a formal rulemaking process. In other words, they should have given notice of the rule. They should have invited public comments. It also claims that it violates the APA, which is the Administrative Procedure Act, because it didn't take into account certain factors like how it would affect faculty members, staff, students, obviously if the schools reopen.
Right.
Because, you know, when the March guidance was introduced, the number of COVID cases was much lower than it is now. Certainly the guidance from the CDC is that opening schools presents the highest risk of spreading COVID-19. So, you know, there's all these factors which the government should have taken into account, and it doesn't look like they have done. So, yeah, I do think there is you know, I think there's a good case. I've read the federal lawsuit. You know, to me, it makes sense. We're obviously going to see a decision on Wednesday, so I think the public could know something by Wednesday or Thursday. If the federal judge decides in the favor of the colleges, then we could see either a restraining order or an injunction. If we see that, then it means that students are going to be able to continue studying online. So that's really obviously the result that we're all hoping for.
So, because as far as I know that, you know, like I've read somewhere that, you know, they are mandatorily have to take online classes. And so then, so tell us a little bit more about that, because I know a lot of students are in a dilemma whether to go because of the pandemic. They're all scared. They're all extremely, you know, feel insecure and, you know, afraid of getting exposed. So what are their options? Like, you know, I mean, if they decide like, okay, so I'll take 3 classes online and 3 classes, like, you know, just to fulfill the requirement or something. So how does it work? What is your advice on that?
Yeah, I mean, the way I see it, 2 things are going to happen. The federal lawsuit will be successful, in which case the new rule will be essentially, you know, it won't go into effect and we'll go back to the March guidance, in which case students will be allowed to continue studying online. If the lawsuit isn't successful, then we're in a situation where, you know, potentially the schools are going to have to make that tough decision whether to reopen or not. Because of the large percentage of international students, I think a lot of schools will probably try and offer some face-to-face instruction, because all the new rule says is that it can't be purely online, which means that if a school can offer some sort of face-to-face instruction, it should be enough to circumvent that rule and allow students to stay in the US. However, you know, there may be some schools that are just not prepared to reopen because they don't want to put their, you know, faculty members, they don't want to risk the health and safety of students. In that case, the students really have 2 options. They either need to transfer to a school that does offer face-to-face instruction, which, you know, bear in mind there's hundreds of thousands of international students, so it's probably feasible, you know, particularly as we're only a few weeks away from the fall semester. Or they could choose to leave the US and potentially study abroad. So the SEVP have said that, you know, it is an option to study abroad. The only problem is that there's people in certain countries that don't have internet access. There's obviously time zone differences. You know, in the lawsuit, it says there's the students from like Syria and Ethiopia where there's civil war, there's no internet access. So for a lot of students that obviously return home, they're really having to abandon their studies. So again, these are factors that should have been taken into account, but appear not to have done. Unfortunately, the options for students will be very limited if the schools decide to continue offering online education.
So, I mean, a lot of students do have their families residing here as well with them, and also, you know, like, so if the rule just changes for the students, you know, so what are the concerns? Like, you know, how does that one affect the families that are staying with them? Like if they have a younger siblings or, you know, something like that.
Yeah, I mean, that's kind of the harsh reality of this rule. You could have, say, you take a family that's come here from India on H1B, H4, the child came at a very young age, maybe 2 or 3 years old. Once that individual turned 21, they're obviously no longer entitled to stay on H4, so they then switch to an F1. Well, the government is saying if that college is only going to offer online courses, you have to go back to your home country. The problem is, all they've ever known, they've grown up in the US. The US is all they've ever known, and their parents are actually, parents and siblings in the US. So,
right.
Obviously the parents and the siblings could potentially stay, but then, where does that leave the student? It's like they're supposed to go home, but the US is their home. So it's a very difficult situation.
So you handled many severe cases. What's the worst case scenario like that you can just, share with us, like maybe, something that we can...
Sorry, the light keeps switching off. It's on for like 2 hours before the call, and then...
That's fine.
So when you say the worst case scenario for a student?
Yes, I mean, such situation that occurred, like, if you ever come across anything that, like, that's, you think that is the severe case that just, so it's a very rare that can happen.
Yeah, I mean, I think the scenario given is probably the most severe case. I mean, the worst case scenario is the federal lawsuit isn't successful. The rule remains in effect, and then, a lot of these universities may offer some face-to-face instruction, in which case those students will be able to remain in the US. The biggest concern is for the universities that say, look, we're going to continue online. That's going to be the worst case scenario, particularly if the student can't transfer to another school that is offering face-to-face instruction. So for those students, they're going to have to leave. And, for some people, they literally may have to just completely abandon their studies. So that's the worst case scenario, but hopefully that's limited to, maybe a small percentage. Some students may be able to transfer, but I think it's going to be very difficult given the time crunch.
Right. So yeah, I think that's probably the next question that I was going to ask, like, what would you suggest that, if that happens and they have to come back in the fall and take face-to-face? Probably that answered the question. So so far that we have discussed a few of these, and so I think it's a good idea to just go over some of the the presidential proclamations and let our viewers know a little bit details about that one. So what changed, and what their do's and don'ts, and then what they have to follow and get more information and stuff. So let's start with that one. For the non-immigrants.
I guess my last comment I wanted to make on the F1 rule was not to make any hasty decisions until you have a decision on Wednesday. Because obviously, once the federal judge makes a decision, Wednesday could be a complete game changer. If we do get an injunction, if we get a temporary restraining order, then we basically go back to that March guidance. So what I would say to students that are, particularly concerned is don't make any decisions to Wednesday. If the rule stays in effect, then the best thing probably to do is to contact the school to see whether they're going to make any type of accommodations to try and offer some sort of face-to-face instruction.
If I'm correct, I think the date was given on July 15th for the final decision that they have to make, and also the August 15th is what they are supposed to be completing their immigration requirements, whatever that is necessary for them to make changes. Is that right?
So the schools have to provide, I think it's the operational change plan by the 15th, which is on Wednesday. But in terms of issuing so anyone that's going back in the fall where there's going to be face-to-face instruction will need a new I-20. And the schools are required to issue those by August 4th. The only problem is that a lot of universities have, 4,000 to 5,000 students.
Right.
So it's going to be very difficult for them to get all those I-20s issued. But I mean, they're very tight deadlines, which again is one of the reasons for the federal lawsuit.
Okay, sounds awesome. Thank you for giving that much information. So let's move on to our little bit of a detailed information about the proclamation. So go ahead and give us, fill us in that, just to get us the correct information about what have been changed so far.
Okay, so there's two proclamations. The first one was on April 22nd, and that applied strictly to immigrants. So that essentially suspended the issuance of green cards for a period of 60 days. It only applies to those outside of the US on the effective date of the proclamation, and for those without a valid visa or official travel document. The proclamation did provide for some exceptions, one of which was, or several of which are lawful permanent residents, EB5 investors, those seeking to enter the US as a physician, nurse, or healthcare professional. There were several more, but there were some exceptions. This proclamation didn't touch on non-immigrant visas, even though President Trump had tweeted, or at least indicated, I think in one of his tweets, that it may include non-immigrants. The second proclamation came on June 22nd, and that effectively extended the first proclamation. So what that means is that anyone who is outside of the US that is seeking a green card will have to wait until, potentially 2021. The second proclamation does include certain non-immigrant categories, and that includes H-1B, H-2B, H-4, and then anyone seeking a J or an L visa. So that would include L-1A, L-1B, and also L-2. So again, these proclamations only affect people outside of the US, whereas when you look at the F-1 rule, that applies to people within the US. So it's certainly different from the F-1 rule, and I think the motivation for these rules is more about Trump fulfilling a campaign promise to limit legal immigration. I mean, the whole rationale behind the proclamations is to protect US jobs.
Right.
If you look at the figures, between the two proclamations, they're only expected to create about 525,000 jobs, but there's 36 million, unemployed Americans. So it makes you think, is this a genuine attempt to actually create jobs, or is it just, part of his re-election campaign?
Absolutely. So, so these proclamations, this affect these applying for the extensions, and also the amendments that are within the U.S. that okay. So go ahead.
So right now the proclamations do not apply to people within the US. So if somebody is looking to file a H-1B transfer, if someone's looking to file an amendment or an extension, those cases are still being adjudicated by USCIS. The only thing that I would say is that the proclamations they provide for modifications in the future going forward. So we could see further restrictions. One other important point is that USCIS are talking about having to furlough 3/4 of their staff. Obviously, if that happens, then that's going to have a profound effect on the adjudication process. So even though the proclamations don't necessarily apply, if there's no one working at USCIS, it's going to be very difficult to obviously obtain approvals.
So we just talked about challenging in the court that SEVP. So do you think these can be challenged as well?
Yeah, I think they can be challenged, and they're probably going to be challenged on the same basis that it's a violation of the APA, that it should have gone through a formal rulemaking process. I think the issue I have with the proclamations is rather than affecting people within the US, Trump is trying to prevent more people coming to the US just to give Americans the opportunity to try and, obviously obtain new jobs. And we're living in unprecedented times. We've got unemployment higher than, the Great Depression. So I think these are potential, and I'm not an expert in federal litigation, but I think these proclamations may be more difficult because the president does have the power under the Immigration and Nationality Act to restrict certain classes of aliens into the US if he deems them to be a threat. The problem with the proclamation is it references spouses and children threatening US workers' jobs. Well, obviously, children can't work. A lot of spouses aren't even entitled to a work authorization. So I think there's parts of the proclamation that could be challenged, but I do think that we are going to see some federal lawsuits pretty soon. And I know that AILA, the American Immigration Lawyers Association, have indicated that a federal lawsuit is probably imminent. So, I think maybe in the next 1 or 2 weeks, we should probably see something on that as well. Yeah.
Right. So, and also, see, these proclamations indicate that the, president intends, that's just, we talked about the further attention to, reduce the legal immigration. So, what do you think that, like in 6 months, like I'm asking you as
Yeah.
a, experienced person. So what is your personal, opinion on that, or something
So,
that you want to say?
in terms of what it's likely to look like in 6 months' time.
Yes.
Yeah, well,
Probably like the second one will be in until December, so there's something is going to change after. So just that's just out of curiosity, just as
sure.
a
So, I mean,
attorney, we of
you
attorneys.
know, a big factor is going to depend on whether Trump gets reelected, right? If Biden gets elected, then I think the landscape is going to be very different.
Uh-huh.
Um, the second proclamation does set out sort of a roadmap in terms of introducing further regulations.
Uh-huh.
So the Department of Homeland Security has been directed to introduce new regulations. Sorry, my lights.
All right. Okay. No worries.
Again. They've been directed to introduce new regulations targeting EB2 and EB3 filings, the H1B program. Trump has certainly indicated that he would like, instead of there being like a H1B lottery, he would like those 85,000 visas to go to the highest paid. So rather than it being a luck of the draw, companies would be competing against companies like Google, Amazon, Facebook. I mean, those companies file thousands and thousands of applications. So obviously, if they get awarded to the highest paid, it's going to be very difficult for small to medium businesses to compete with the likes of those companies. Now, there's a lot of things in the works. There's a lot of indication that further restrictions are coming, but I do think that a lot of that is going to depend on the election in November.
First. Okay. Well, fair enough. Fair enough. So I do have some questions from, like, the viewers. So let me go over one by one. So let's see. Um, Okay, so the first one is, it's about the question on a Dropbox. Usually it will be available for people who have the extension with 1 year, and how will it be affected during the executive order and post-executive order? That's one of the questions that was posted. Okay, go ahead.
Okay. So, I mean, for people that aren't familiar with the Dropbox facility, that's essentially allows somebody that's applying for a second visa or a subsequent visa that's where the previous visa had expired within the last 12 months, and it allows them to submit documents to a visa application center to avoid having to attend an interview. So, as far as I'm aware, the Dropbox facility is not available right now because A, the consulates are closed, and B, obviously we have proclamations suspending the issuance of visas. Going forward, again, it's going to depend on who gets elected as president in November. But the second proclamation does mention the need for biometrics. So the Department of Homeland Security is required to ensure that anyone that goes for a visa is going to have to give biometrics, and that includes a photograph, a signature, and fingerprints. So I think going forward, anyone that's applying for a visa is likely to have to go for an interview. So, that's my personal opinion, but based on what we're seeing so far, I think it's unlikely that Dropbox facility will continue unless, we see a different president being elected.
And okay, that makes sense. Okay, so I hope it answered a question that you asked. And moving on, like, if you are on H4 EAD, can I run a home business? If so, what kind of visa permit do I need?
Okay, so somebody that gets a H4 EAD, it's an unrestricted employment authorization, which basically means that they can work anywhere, they can set up a business, they can set up a home business. The only word of caution I would mention is that the H4 EAD doesn't qualify for an automatic extension, which means there can often be a gap between EADs. I'm not sure whether you saw over the weekend, there was a news article that says that USCIS is actually stopping printing work authorizations and green cards. So what that means is that somebody could be approved for an EAD and not actually get the physical card. So, somebody that sets up a business may find themselves in a situation where one EAD comes to an end, and then there's a 6-month gap, before the next EAD. If that happens, then they would have to stop running that business, or they would have to get somebody to run that business on their behalf. So they can certainly set up the home business, but they need to make sure that as soon as that EAD comes to an end, they don't continue the business until they get a new EAD, which, based on the fact that USCIS are saying that they're not going to print them for the foreseeable future, I think that's going to be a real issue.
So, okay, so so this one is, I think, from a question from a student. So does the financial aid get waived in case of a deportation of me, which is a student? So, yeah.
Okay, so I think this question is really asking if somebody's taken financial aid, and then maybe as a result of this new F1 rule, they get deported, is that financial aid going to be waived? This is probably a question for the school. The student would need to look at the terms and conditions upon which the financial aid was taken, but I wouldn't expect the financial aid to be waived in the event of a deportation, because a deportation essentially means that somebody has violated their F1 status. If somebody violates their F1 status and is deported, then the school is likely to say, well, look, that's on you. You got deported because you didn't follow the rules. But again, they would need to check the terms and conditions. But I think it would be extremely unlikely that financial aid would be waived. Obviously, if that person is deported back to their home country, enforcing that and actually recovering that financial aid may be a different story.
Oh, wow. Okay. Well, that makes sense. So the next question is, like, I work in a healthcare. My green card is under process. Do I need to be concerned?
Okay. And do we know whether this person is in the US or not?
Yes, he is in the US. He's in the US and working as well. Yes.
Okay. So if this person is in the US, they're not covered by the 2 proclamations. Okay. Obviously, we could see modifications going forward, but I wouldn't be overly concerned, because certainly the first proclamation made an exception for healthcare workers. Obviously, with everything that's going on right now, I think healthcare workers are probably needed more than any other type of worker. So, as I say, the proclamations don't affect anyone within the US. So somebody that's going through the PERM process, an I-140, a 485, but again, they may experience an increase in processing times. But I certainly wouldn't be overly concerned, because I think they're probably in a fairly good spot if they're within the US and they're working in that field.
Okay, so let me, it's completely little bit of sidetracking, but that also concerning questions for the healthcare, like the worker. So what if they cannot work? Like, what if they get sick by COVID, and then they have to be, like in a difficult situation? You know what I'm saying? So what would be the scenario? Like,
if they get sick.
It's a difficult question, I know.
Yeah, it's a difficult question. It's probably going to depend on where they work and what the policy is on sick pay and everything else. Obviously, it's going to depend on how severe their symptoms are. If somebody gets sick and they're off for 2 or 3 weeks, the reality is they should be able to go back to work. If somebody is off for several months, again, it's going to depend on where they work, if they're going to be able to continue to go back to work. But that shouldn't necessarily affect the green card process, because the green card process can be for future employment. But I think that's probably more of a fact-specific scenario, and it's going to depend on the facts of the case.
So what if the status is different than just the green card? So then should they be concerned at all? Like, not the green card, but the temporary basis that working here for a short period of contract or something like that. So should they be?
Like, so for example, if somebody was on a H-1B and got sick?
Yes.
Yeah. I mean, they are allowed to take, sick leave under the Family and Medical Leave Act. So I don't think they would necessarily need to be overly concerned. But again, I think it depends on, the length of sickness. Certainly, I would expect them to have a job when they recover. But again, it's probably fact specific, because if they're working in a position which is critical to the organization and they're undergoing long-term sickness, it's possible that they may not have a job to go back to. But I think that's probably a question more for an employment-based attorney.
Okay.
Not necessarily an immigration attorney.
Okay. So I think definitely, please do, call Chris, and he also will help with those, if I'm correct, right? So
yeah, my email is going along the bottom of the screen, so I think everybody can view that. So I would say if people have questions related to, the F1 rule or the proclamations, if they have fact-specific scenarios, by all means send me an email, and I'll certainly be happy to answer any questions.
Okay. So let's move on to the next question. Thank you. My husband's H-1B visa will be revoked, this coming Friday, and I'm a realtor as an independent contractor on H-4 EAD. Once my husband's H-1B gets revoked, what would be the status of my H-4 EAD? Can I still work?
Okay, so again, this is probably fact specific, but the H-4 and the EAD depend on the principal H-1B holder maintaining status. So typically when somebody loses a job on H-1B, as long as they have sufficient time left on the I-94, then they'll be entitled to a 60-day grace period. During that 60-day grace period, they continue to maintain H-1B status, which means the H-4 holder would also maintain their status and would also be entitled to use the EAD.
Okay.
However, if they get to the end of the 60 days and the H-4 holder is not able to find a new job and file a new petition, then just because the expiration date on the EAD may be 6 months from now, if the H-1B holder isn't maintaining their status, that EAD would become invalid. So it's kind of crucial that the H-1B holder is able to find a new job and file within that 60-day grace period. It could be less than 60 days, depending on how long they have left on their I-94. But if a new petition is filed, then they can continue to stay in H-4 status and use the EAD. But that's perhaps a scenario where if that individual wants to send me an email, I'd be more than happy to discuss it with them. Because,
sounds great.
It depends where they are in the process, if they're getting to the end of the 60 days. But if the H-1B holder doesn't have an opportunity to get a new job, then that EAD would become invalid.
So, yeah, I mean, your services will be throughout the nation, so I don't think they will have any issues, even though they're out of Texas or anywhere else, so they can still contact you and get their question answered and also. So that's great. Looks like the next question is probably connected to this one as well. It says that my child is a U.S. citizen minor and her passport is expired. And her father's H-1B gets revoked in case if they have to leave the country. So how can that be best handled, as the passports are not being issued or renewed, immediately at this time? So.
Yeah, I mean, that's a very difficult situation. What I would say is, the passports are still being issued, but obviously the processing time is, much slower than it was. And the only reason I know that is because I applied for a US passport about 5 months ago. It should have taken 6 weeks, and it took about 4 to 5 months. There is a process to expedite passports, but I think if this family is in a situation where they can't leave, there's a good argument that they certainly wouldn't accrue any unlawful presence because it's impossible for them to leave. I mean, my only advice would be to contact the passport office, explain the situation, and see if that passport request can be expedited.
Okay, so that one is probably that, also the similar, that if they have any more detailed questions, that I think I would recommend just, please do call the Patel Legal or send them an email so that, they can, or you can also, contact them. the Chris will be happy to help you with all the the questions you may have. So one more, I mean, if anyone else has, please go ahead. And at this point that I think we're going to take another 10 minutes, maybe the
Okay.
questions from live. But in the before that, what I want to say, I know this one probably may be best handled at the office, contacting you, but just try to see if you can answer best. The one, this is about the EB1A, and I believe they've applied and submitted in March last year. So if it is a counselor, like in a different country, like the reason that I'm asking is many of them, they are choosing the India or other country as their counselor processing base. So
Yes.
if that one happens, then if they do not receive their green card and interview before, so how do they, I mean, what do they need to do in case if they have a child that that like to protect them?
So in other words, if they have a child that could potentially age out.
Right.
Okay, so the first proclamation didn't really provide any exemptions for childs that age out. The second proclamation did. So if the sole reason for the child aging out is because of the ban, and obviously because of the consulate closures, then they should still be entitled to the visa. If this person would have aged out anyway, then they're probably ultimately going to miss out on the visa. But if it's purely as a result of this ban, then the second proclamation does provide that exception. So, I mean, hopefully that's good news. Again, this may be fact specific, where we would have to look at, when the child ages out, and I'm more than happy to kind of look at that scenario if the person that submitted that question would like to send me an email.
Okay, because like if the viewers are wondering what, because like once the child turns 21, then that is where the issue comes, and then if they don't get their green card interview by then they will be in a big dilemma whether the child can stay with them, or because they will be a legal adult at that time, and then so they have to face a different issue at that time. So yeah, that answered the question, and thank you, Chris. I really appreciate it. And I think we have one more question. What students have to do if the university works remote classes but in synchronous mode? I'm not sure what that is, but I'm not sure. Is there a fear factor for students who are already there? I'm not sure what that means. Okay, so probably what they want to ask is, if they're already taking, like a lot of students, they don't even register as a regular student, so they work part-time and then register as a students. And then what would be the scenario for these students that if they don't have any choice at all, like other than just taking online courses?
So if they're at a university that says they're only going to continue to take online courses?
Yes, only online courses, yes.
Yeah, I mean, that's the situation where they either have to transfer to another school or leave the US.
Oh,
so
okay.
The people that leave the US, if the school is only offering online instruction, the SEBP have said that they can continue to study abroad. And I think we touched on that earlier, but again, it's going to depend on whether it's possible for them to attend every single online class, because the time zone difference is going to be a huge issue. And depending on what country they're from, if they're from India, for example, they'll probably have, or potentially have good internet access, in which case, as long as they can attend every online class, they can continue to study. And the other thing Sorry,
that's the only way that they can actually save themselves as remain as a student here, by transferring to the different school.
Correct. Yeah. I mean, if the school is insistent and says, look, we're not prepared to offer anything but online instruction, the only way to stay in the US and continue to study would be to transfer to another school. But the reality is, a lot of people select the school they want to go to and are probably not going to be keen to transfer to another school. So perhaps studying abroad may be the better option, but it depends on the individual circumstances if that's even a possibility.
So excellent. Well, thank you. Okay, let's see. Are there any special steps that like students are also working sometimes that employers can help needed to begin, or something like that that can help with? Is there any way?
Sorry, is there any steps that employers need to take?
Right.
I don't think, at this point, based on the new rule, I don't think there's anything that employers can do to help intervene.
Uh-huh.
You know, I think everything is really kind of hinging on this lawsuit that's going to happen on Wednesday. That's really going to be the deciding factor as to, whether schools have to reopen or whether students are going to be permitted to continue to study online.
Okay, I believe this question, if I understood correctly, don't you think it will affect the students in the universities if employers don't support them, or something like that? Like, if they are supposed to leave the work. I'm not sure what they're trying to ask, but does that make sense to you at all?
I think it was kind of similar to the last question.
Last question.
This,
Okay.
this new rule isn't about, people that are here on OPT or STEM OPT that are necessarily
Oh,
working.
yes.
This
Okay.
is more about people studying, whether they're studying online or whether there's some sort of face-to-face instruction. So
Right.
while the employer may be, fully supportive of them, it really comes down to what the school's prepared to do. If the school is prepared to offer some sort of face-to-face instruction, that is going to allow them to stay. And the one thing that one thing I can kind of glean from the guidance is it doesn't say how much face-to-face instruction is required. So as long as there is some face-to-face instruction, even if it's 5 or 10%, it should be enough to allow the student to stay. And again, they have to get a revised I-20 to show that they're attending a course which is not going to be purely online.
Okay, that just just now that occurred to me that, when you said that, in talking about this employers OPT issue, talking about that, like some of them are already graduated and their period is like they're still 3 months, 4 months, still remained on their, the period here just to find the job. So what happens to them? Like, what is the situation with them? Like, how can they handle this?
Yeah, I mean, if they've already graduated and they're on OPT, STEM OPT, then they don't this new rule doesn't affect them.
Even though they don't have a job, they have not found any jobs yet, and they're still
yeah, I
seeking
mean,
one.
Yeah, I mean, there is a limit on the number of days of unemployment. So for OPT, it's 90 days. If it's STEM OPT, it extends to 150 days. If students find themselves in a position where they're going over those number of days, then that's going to be a real issue, because obviously that would be considered a violation of their F1 status, and it would invalidate their work authorization. So, I mean, the key is obviously try not to exceed those number of days, but for students that just can't find work, unfortunately, it probably means they're going to have to leave the US.
So, well, that's really sad, but yes, that's a reality.
It is
that
sad,
they have to.
and I think H-1B holders are in a similar position. A lot of H-1B holders have lost projects. They're struggling to find new work, and unless they can find a new job, they're ultimately going to lose the H-1B and probably have to kind of make a decision whether to return back to their home country. And it's easy for me to say that, but I know that there's people that have been here for several years. They own homes, everything else. So it's definitely provided a lot of uncertainty for a lot of people.
Okay, I think I got a response back. I think they're listening to you, so they just sent me back this response. So I think this is kind of a revised question that we asked. What students have to do if their university works remote classes, but in synchronous mode, meaning students attend online at the same time the professor gives the lecture. Means like they're talking about the Skype or Zoom lessons or something. It's considered as that, and student complete the course at a distance. I meant to ask, should the students there need to be concerned that they have to look at admission again?
Yeah, I mean, if it's, anything that's being conducted online, so if it's being done over Skype, would still be considered a purely online course. So if the school is going to continue to operate under those circumstances, that would require the student to either transfer, because when we're talking about transferring to a school with face-to-face instruction, it means in person. It doesn't mean
Right.
over.
Oh, okay. So that will be concerned as face-to-face, like
That
not in the
that
classroom,
wouldn't
but
be that wouldn't be considered in per. You know, we use the term face-to-face in the same way
right,
that we're face-to-face. But what they mean is in-person instruction. I mean, the
right,
whole
in the same room.
yeah, in the same room, lecture at the front. You
Right,
know, that's
right,
what
right,
we're really
right,
referring to.
right. So, okay, so our next question is about what options do people like my in-laws have who are very old and cannot return to India, even if the flight resume and their visa expires here?
Okay, so I mean, are these people that have perhaps come on like a visitor visa, like
Visitor visa. Maybe
yeah?
they're just a little bit longer, like more than 3 months, but definitely visitor visa. Yes, they're
Okay,
not
so
citizens or green card holders.
yeah, I mean, we've had a lot of situations like that where they're
Uh-huh.
still within the authorized stay.
Uh-huh.
If that's the case, then they can always apply for an extension.
Uh-huh.
If they've gone beyond the authorized stay, then it's going to be a potential problem. I think if it's, you know, there's some real health concerns, you could still potentially file an application to extend that visitor visa, but there's a good chance that that application would be denied. And the problem is that type of application is likely to take about 6 months. And
Uh-huh.
if somebody stays for that amount of time, then they could accrue unlawful presence of 6 months, which would then subject them to a bar, which would
Right.
prevent them from coming back in the future. But if somebody is seriously ill to the point where they can't leave,
Uh-huh.
then, you know, the law doesn't compel the impossible. So if somebody can't leave, they would
Uh-huh.
have a good argument that they don't accrue any unlawful presence. But I think that's going to be a very fact-specific case.
Uh-huh.
One thing being concerned about traveling, but it's another thing if somebody's in ICU and obviously they can't travel.
Absolutely. So, so if they apply for extension, so how long can they apply for? Like, is there a time limit, like 90 days, 60 days? So,
So
or
yeah, so if it's a visitor visa and they've been admitted for 6 months, they can apply for an additional 6 months.
uh-huh.
Quite often is the case is that it will take longer than 6 months for that case to be adjudicated. Sometimes it may take 8 months, but whenever that case is approved, it's only going to be approved for a 6 month period, which means that they can apply for 6 months. Let's
Uh-huh.
say in 6 months' time, you know, the number of COVID cases has increased, travel concerns are, you know, greater than what they are now, they could
Uh-huh.
potentially submit a second extension request.
Uh-huh.
But we don't know how USCIS is going to consider that.
Right.
There's certainly a lot of these types of applications at the moment, particularly
Uh-huh.
with, you know, people that are elderly and
Uh-huh.
more, you know, potentially prone to catching COVID.
Yes, because the main concern of these, like the elderly is the insurance, and then probably they also have a different type of insurance. They come on visitor visa, and then if that expires, and that also is the biggest concern of health in case if they get sick here. So that probably will not help much. So, and how, Chris, how long does it take? I mean, like how soon do they need to be applying in case if they think that, that they will not be able to go back for such a period of time, for example, like if they need a 60-day extension, so how soon should they like apply, and then they get it immediately?
Yeah, so they would need to apply before the expiration of their current authorized period of stay. So if
Uh-huh.
somebody, if somebody comes in for a 6 month stay, they would
Uh-huh.
need to make sure they apply before that 6 month expires,
Uh-huh.
because then it would be considered to be a timely filed application.
Okay.
If filed after the 6 months, then it's really up to the discretion of the officer, and that type of application is more likely to be denied.
Okay, so that's a wonderful way to avoid that such a situation for them to have some good feeling about it. So, um, the next one is how will, I mean, I guess you already answered this question probably, and they also asked it, especially because they would have come here, the huge student. Okay, so this is regarding the students who are coming here with the large amount of loans, and then, their OPT expired, or maybe even the student loan that they came here and then immediately they're asked to go back. How will the university or government handle that? Would the loan be reimbursed or waived? That's the same question. So if you don't mind, go ahead and you say, probably this is a repeat question that we already answered that in the beginning of
Yeah, I
the
mean,
sessions. Okay.
yeah, I think it depends on the circumstances upon which
Mhm.
they leave. Obviously, if they if they do get deported and it's a violation of F1 status,
Mhm.
I don't think that they would necessarily waive that financial aid.
Mhm.
I guess I don't know if this question is more getting at the situation where they've already paid tuition and then they're being
Okay.
forced to leave the US. For example, if they paid for the full semester and then the school says, look, we're only going to offer online courses, in which case you need to leave. Well, is the school then going to reimburse those tuition fees? I
Mhm.
don't know. I think that's going to depend on, the school's policy. Certainly as a student, if I've paid tuition fees and then I'm being told that I can no longer study and I have to go home, particularly if I'm studying from abroad, are they going to, give back some of those fees? Are they going to reimburse them? I,
Okay.
I don't know. That's really a question for the DSO, for the school.
For school
And it
and
may vary from school to school. Some schools may be prepared to reimburse. Other schools may say, well, look, it's not our fault that you guys have to leave. I think that would be a fairly harsh consequence.
consequences.
So the hope is that if they can't provide the tuition, they should be reimbursed those fees. But again, that's something they would have to take up with.
Right. Right. Because I think, especially the scenarios, so probably would be already, like these doctorate students or the people that who are required to already, pay that one before they even graduate. And then I think that probably applies to them more than any other students for the higher studies, if I'm correct. So, okay, this is very unique one. I think that can students transfer to Wisdorisa and then switch back to F1 status when the university starts classes in person? That's a
Um,
very good question.
Yeah, I mean that's one of the options right now is to file a change of status to, for example, a B1, B2,
Oh, okay.
because if somebody wants to remain in the US, they can certainly file a change of status application. The only problem is that when you file for a B1, B2, you've
Mm-hmm.
obviously got to show that you've got the financial support to remain in the US, but then you've also got to show that at the end of the stay that it's your intention to go back to your home country. If USCIS think that the only reason you're filing that change of status is to allow you to stay until classes resume, there's a possibility USCIS may deny that type of application, particularly
Mm-hmm.
if we see a lot of those types of applications, because essentially people would be filing it to circumvent this new rule.
Mm-hmm.
I think there's somebody that maybe has been here for more time that can justify, look, there's things I need to take care of. I can't just simply leave. It's certainly a possibility.
So,
Um, Sorry.
no, I was just saying that, just in case if they have only 2 semesters left before their graduation, so that would be a good idea, just instead of leaving, like, just a curious.
Yeah, it's certainly an option. The problem is, if that application gets denied and they ultimately have to leave, it could
Mm-hmm.
then have an impact on future applications because when they try and come back into the US, they
Mm-hmm.
may get asked, well, why did you not leave? So
Mm-hmm.
they would have to properly document that type of application. I think there would have to be a real justification for that application more than, look, I just want to stay until they resume classes. I don't
Mm-hmm.
think that's probably going to be a strong enough argument. But again, there may be individual circumstances that warrant somebody needing to stay. So it's certainly a possibility.
So, well, I think probably that's going to be one more, um, just a last question that's going to be for this one. Any change in status is going to take a long time. I understand. Then, do they get deported at that point?
I mean, if the application gets to, so as long as the change of status application is filed timely, in other words, prior to the authorized stay, that allows the individual to stay while the application is pending, as long as they don't consider it to be a frivolous application. So if they get to the point where, you know, they request 6 months and the 6 months is up and they still don't have a decision, they would need to leave. If the application gets denied and they decide not to leave, then they would potentially face deportation. Or at least, you know, it's the potential for deportation. It doesn't mean that it will actually happen, but it's certainly a possibility.
Well, we would just recommend, like, don't get any, you know, the violation tickets for driving, so you will be safe until then.
Yeah, I think it, you know, the advice to people is not put yourself in a position where you could be deported.
Right.
You know, if it gets to the point where you can only attend online classes, you need to, if you can't transfer to a different school, don't just remain in the US, because then you're really putting yourself in a position where you could be deported. And that's obviously not the ideal scenario.
So, well, to wrap up with, so tell us, like, you know, just give your closing remarks, that, you know, just what, you know, your advice in all, so that, you know, we can, I mean, we can also do one more if possible, like in the future also, like, you know, in case if any changes happen, and then if opportunity, you know, comes, then yeah, but I'm going to have to give you, you know, let you have the final remarks so that, you know, we can close the show.
Yeah, I think as far as the F1 rule is concerned, you know, the same advice that I gave earlier, I would just keep tabs on this federal lawsuit that was filed by Harvard and MIT. We should have an update Wednesday or Thursday. I'm more than happy to come back and discuss that update. I'll probably publish something on our website, so if people want to look out on our website,
absolutely,
will be an update. Hopefully it's going to be a favorable update, and, you know, that's going to allow people to remain in the US.
Right.
There's not going to be any additional concerns. What I would say is, obviously, just keep tabs on everything that's going on. If you're on a H-1B, make sure you keep up to date on everything that's going on. Read the proclamations, because they do affect a lot of different people. Again, you know, let's see how things pan out over the next few months. If Trump gets reelected, we are likely to see a lot of further restrictions. We may see changes to the H-1B program. If Trump doesn't get reelected, I think we're going to see a much more favorable immigration landscape. We probably all, you know, maybe breathe a little bit easier. But yeah, I think that's all that I can probably say at the moment. You know, 2 or 3 days time, you know, let's see how things lie, and we'll kind of take it from there, if that makes sense.
And also, like, you know, we immigration is not the only specialization of the Patel Law Group. So tell us a little bit about OCO, because I know that we have so many viewers that may have a different concerns about, and they want to reach out. So tell us a little bit about the Patel Law Group, and give us, you know, some information.
Sure. So we have 3 offices. I work in the Irving office in Dallas. We also have an office in Houston and Oklahoma. We consider ourselves to be a full-service law firm, so we deal with real estate transactions, personal injury cases, you know, family, divorce, all sorts of litigation. We also file federal litigation in relation to immigration lawsuits. So I think if anyone listening has any type of legal concern, they can certainly email me, and I'll make sure that gets fielded to the appropriate attorney. But yeah, we definitely do a lot more than immigration. And even though I specialize in business immigration, I also handle a lot of family-based immigration, so kind of marriage-based petitions, fiance visas. So, you know, at the end of the day, just email us. You know, if it's something that we can't deal with in-house, we can certainly make a referral to another, you know, kind of recommended attorney.
And the offices are throughout the nation, so anywhere that, you know, you can get them help, and so that is one of the plus of this law firm.
Yeah, and immigration is a federal subject, so we represent people all over the US. So, and obviously, even people outside of the US. So,
Mhm.
we're not restricted to a certain geographic location. We can handle cases from, all over the US.
So that's wonderful, Chris, and I would like to thank you. And if any of you have any questions, like about your immigration, so do email him, cprescott@patellegal.com, and for more information. And also, you can visit our Facebook page for more information. And this show will be available for you to view even after on a YouTube channel as well as the Facebook Live. So if you have more questions, please do email him, and you can also reach out to him for answering all your concerns. So thank you so much. Would like to thank you for coming and answering all the questions today. And it's a pleasure. And let's hope that, in the future also, we will make one more session of this one to help more to the community. Thank you.
Definitely, yeah. Thank you for having me on the show. I appreciate there's a lot of things going on, and as you say, there's probably going to be future opportunities to talk about further immigration changes. So, I'm more than happy to kind of educate the community.
Oh, well, thank you. And just, the Kaish News team rocks. And thank you so much for joining, even from India, all of you who are watching and supporting. And definitely, it's a pleasure having you all on the team. And let's keep rocking. So thank you so much. And let's see you again next week with more on Asia News FB Live. And this is your host, Anu. Thank you so much for joining. Thank you.
Thank you.